on the show is Luke Berg from the Wisconsin Institute for Law and Liberty. The Wisconsin Institute for Law and Liberty looking to get to the United States Supreme Court again, this time on behalf of students in public schools. So what is going on? Why all the way to the United States Supreme Court with this particular case, which has to do with the Eau Claire school district hiding gender transitions from parents?
Hi, thanks for having me on. Yeah, so this is one of 3 cases that we've had so far against public school districts for keeping gender identity transitions at school secret from parents. I don't know if your listeners remember. You remember this is the school district that trained all of its staff that parents do not have a right to know their kids' identities at school, but must earn that right. So that tells you a little bit about something about how the school district thinks about parents. So we challenged this policy on behalf of an association of parents who all have children in the school district, but we lost at the district court and the Court of Appeals. Both said the parents don't have standing until they can show that the district has already secretly transitioned their child, which I think is crazy because, of course, if they've secretly transitioned your child, how do you know? So we're asking the Supreme Court to weigh in and to reverse that decision on standing.
Wow. So parents can't protect their kids. Parents have to wait until their kids are harmed. Their kids are harmed. And then the courts in Wisconsin say, okay, then maybe we'll let you sue. But we got to wait until your kid is potentially irrevocably harmed by a school policy, not even the law, just a policy that was adopted. And then maybe you'll have a chance after your kid is miserable and maybe even suicidal.
Yes, that's the net effect of the lower court's rulings, and it's crazy, right? I mean, if you can't sue preemptively, the only way to protect your kids is to pull them from public school, because the school districts are telling you when the serious issue arises with your kid, we're going to make the decision for you and we're going to hide it from you. So if you can't challenge that in advance, then I guess you got to pull your kids from public school.
A policy. Let's just use a different policy here. Let's just say the Eau Claire school district decided to adopt a policy that was going to hide from parents that their children were sexually assaulted by another student. Let's just say, for example, nobody would accept that, Luke. Nobody would accept you saying you're going to have to wait until your kid is sexually assaulted until you can challenge this policy. That's insane, right? Right.
Or take another example. If a school district said, yeah, we're going to just have the medication drawer and we're going to open it up to students and they can take whatever they want and we'll just keep it a secret from the parents. Don't worry about it. You take whatever you want at school while you're there, right? Nobody would say, well, we got to wait till some kid ODs and then they can challenge it. No, of course you could be able to challenge that preemptively. I think this is federal courts around the country, and it's not just been our case. It's been a number of cases that have lost on standing, trying to avoid the merits of this because it's just so bad for the school district. And it's really sad to see the failure of the federal court system, in my view. We have probably the most blatant and widespread violation of parental rights perhaps ever. And there's like 30 of these cases around the country, and only a couple of them have won so far, in part because courts just keep kicking them on all these stupid stuff that I think is wrong. And so that's the story we're trying to tell to the Supreme Court. Federal courts are failing.
If this isn't standing, I mean, then how do you define standing? And then what do we have to contort ourselves and play intellectual twister with language to suggest that these parents would not have standing? That's absolutely bananas. And I don't think that's. Go ahead.
Part of what I think the court is not seeing is a lot of these cases, parents have discovered that their children have been secretly transitioned. Now, it's often months after the fact, but put yourself in the shoes of a parent in that situation. Do you leave your child in the school district long enough to litigate it for a year and a half? Of course not. You immediately pull your child from the school district. And so then courts are saying, well, it's no longer a live issue because you're not in the school district anymore.
Wow.
And the defendants have qualified immunity, so you can't get damages. And it doesn't violate the rights because it doesn't, it's not egregious enough to shock the conscience. So, even though it might violate their rights, I'm just going to kick your case on that ground. So the cases are just getting kicked left and right.
We have dumb judges, or we have corrupt judges who are doing that.
Really
it's either
sad,
you're either thoughtless, or you're thoughtless or stupid or sadistic and awful. What is the parental rights law in Wisconsin? Because as we're talking about, well, there's a law that says you can't just open up a drawer and let kids grab drugs, or there's a law that says you can't sexually assault a kid. By the way, school districts hide sexual assault from parents across the country relatively routinely. I want to point that out. But what is the parents' rights law in Wisconsin? How is this even something that needs to rise to the level of a lawsuit?
Well, so parental rights are primarily protected constitutionally. There's been a long sort of series of Supreme Court cases where the court has recognized that parents are the primary decision makers with respect to their kids. Because of that, that has just been sort of the background norm that everybody has been operating under forever. So, there are some laws that address nuances here and there, but there's not sort of one generic, broad state law that addresses all parental rights issues. It's mostly a constitutional issue. It's both protected by the federal constitution and the state constitution. And until recently, schools have respected that. And most decisions at school, you get parental consent for them. Schools will defer to you.
Okay, but they have lawyers. They have lawyers, right? The school districts have lawyers. So the lawyers surely would know about the constitutional precedents that say you can't do an end run around parents' rights.
Yeah, you would think so. But I think what happened is some activists pushed these policies on school districts on a few, and then it just kind of spread like a cancer from school district to school district, echoing to one another. One of the arguments you hear is, oh, Title IX requires this. Title IX doesn't say anything about this. And in fact, the Biden administration, in its most recent Title IX rule, the one that's getting sued over all over the country right now, ran hard away from these policies. It even said explicitly, no, nothing in Title IX requires you to ignore parents. If there's a dispute between a student and parents, you should defer to the parents. That's the Biden administration. So, I just think this was bad lawyering by any lawyers who were advising school districts. This was just ill-advised and poorly thought out by school districts. And one would hope when they got called out, they would back off and be like, yeah, this was a mistake and change the policy. But a bunch of them have not. And so now we're in litigation, and now
Right.
It's up to the U.S. Supreme Court, hopefully.
You've been involved in multiple cases where parents have said, my children are being transitioned against my permission, against my will. Madison being one of them with a policy, that they shrugged their shoulders. Kettle Moraine, now Eau Claire. It doesn't matter when you win one, does it?
Apparently not. No. We were happy to win the Kettle Moraine one. That was the first one in the country actually to win a final decision on the merits, and the Kettle Moraine School District backed off and changed its policy. But Eau Claire, when they got called out, doubled down, and so now we're still in litigation with them. And it's really sad to see what this is doing to young people across the country. If anybody wants to sort of see the full story, I encourage them to read our petition, because we really survey all the cases around the country, and there's multiple where students have actually attempted suicide before the school told the parents that they were dealing with gender dysphoria. So that just goes to show you how serious this issue is and why it's so important that parents be involved.
Yeah, it's also why it's so important for parents to have the decision-making authority here. And again, the reason I brought up the parental rights protections in Wisconsin, and it doesn't matter if they're in statute or in the Constitution, they're there. They're
Right.
there. So you can't say, well, there's no law against the school district taking away parents' rights. Yeah, there's constitutional precedent, which is the law. So, as we use these examples, and by the way, there's no limiting principle. When the school districts decide, these people who spend teachers who spend 1 hour a day, 53 minutes a day with your kid, or an administrator that spends zero time ever with your kid, or other paper pushers or lawyers who spend no time. And they're the ones who are claiming that they should be able to substitute their will for your rights over your children. There's no limiting principle. Once you let it happen, if courts refuse to rein it in, if legislatures refuse to rein it in, what's next? You should all ask yourselves, what's next? Because the answer is we don't know. It could get worse than this if that's even possible.
Yeah, that is a hugely important point, and why this is so important is this is the start of the slippery slope, and if they can do this, they can do anything. So
Oh, yeah.
Yeah,
I don't
really
think
hope
it's
the
the
court
start.
takes the case. I hope we win.
I don't think it's the start of the slippery slope. I think we're like, almost to the bottom of it because
fair.
this is pretty bad.
We've gone off the edge.
And if parents out there are wondering, what can I do? My school district's doing, my school district is doing this to kids. You need to reach out to Wisconsin Institute for Law and Liberty. We're one of the few states that can boast having a really robust public interest legal representation, environment for parents in Wisconsin. So how can people, reach out and get in touch with an attorney?
They can email me directly. My email address is luke@will-law.org. So I'd love to hear from any parents if you're dealing with this issue.
Luke@will-law.org. I appreciate you providing your direct email. That's really nice of you. Luke Berg, thanks very much for joining me on the program today.
Thanks so much for having me on.
Good to have you. And I will take a break on the Vicki McKenna Show.